Here's an outline of my talk. I'm going to start with some DNA cases because they provide good illustrations of the various fallacies which can arise when probabilities are discussed in court. Then I'll look at some profile cases. These are cases where the accused don't necessarily have any direct connection with a crime, but where they've had an appropriate personality or behavioural profile. I'll then look at some probabilities of coincidence, and this will lead into the cot death cases, cases where mothers have lost 2 or 3 babies to sudden unexpected deaths and then found themselves accused of their murder. I'll then look at a salt poisoning case, and finally we'll have a look at whether there might have been a miscarriage of justice involved in the case of Harold Shipman. The cases I've been most involved with myself are the cot death cases, and I could easily have spent the whole hour talking about them. But to do so would be to repeat what you can read about in my published papers, so I thought I'd just give a brief summary of those cases today. I prepared a reading list, which is probably too small for you to see, but this is also on the LMS website. My 3 papers are there in the middle. If anyone would like to read those, do feel free to send me an email. So let's start with DNA evidence. So suppose a crime is committed and that the criminal has left a sample of DNA at the scene. Now, depending on how good that sample is, you can assign something called the match probability to that sample. And that is the probability that if you pick someone at random, their DNA would match the crime sample. This is usually quite a small number. It's typically 1 in several million or even 1 in several billion. Now, a person chosen at random is almost certainly innocent. And so this match probability is, in effect, the probability of a match, if innocent. What it is definitely not is the probability of innocence if a match. But that second probability is the one that the jury's interested in, because they see the accused before them who is known to be a match, and they must decide whether that person is innocent. But if the jury interpret the match probability of, say, 1 in a million as meaning that there's only a 1 in a million chance that that person is innocent, then they would be committing the prosecutor's fallacy, which is the error of getting these 2 conditional probabilities the wrong way around. The 2 probabilities are related by something called Bayes' formula, which we'll meet later, but they're quite definitely not the same. It's vital to distinguish between what I call strong DNA evidence, where the accused is a suspect for other reasons, and then the DNA is found to match, and weak DNA evidence, where the accused is a suspect because there's a DNA match found by a trawl of the DNA database. And I should stress that this use of strong and weak isn't standard terminology. It's terminology I'm introducing for the purposes of this talk. So, for example, suppose the match probability is 1 in a million. Now, if this is strong DNA evidence, then it adds huge weight to the prosecution case. But if it's weak DNA evidence, the defence can argue that the accused is just one of about 50 persons in the UK, which has an adult population of 50 million, who are equally likely to have done it. In that situation, it's essential for the prosecution to have a strong case based on other evidence. However, if the defence argue that the probability of guilt is only 1 in 50 in a case of strong DNA evidence, then they'd be committing what is known as the defendant's fallacy, because that probability doesn't take account of all the evidence which led to that person being a suspect in the first place. Well, straight away we have a big question, and that is, how does the jury know whether the DNA evidence is strong or weak? If I were on a jury, that's the first thing I'd want to know. But it's not clear that the judge could give that information. The information that the evidence is weak, that is found by a trawl of the database, would imply that the accused is almost certainly a previous offender, because only the DNA of people who've been arrested for a crime gets stored on the national database. So this leads to a further big question. Should previous convictions be made known to juries during the trial? Current law allows this only if there is what's called similar fact evidence, that is, striking similarities between two cases. And the change in this law is said to be a high priority for Prime Minister David Cameron. But I'd urge caution on anyone advocating such a change, because there's another fallacy which deals with precisely this situation. This is the jury observation fallacy, introduced by Fenton and Neal in 2000. The scenario is that the jury finds a defendant not guilty. It's then revealed that the defendant had previous convictions for a similar crime. The jurors are distraught, thinking they've let a guilty person go free. But Fenton and Neal claim that post-verdict knowledge that an acquitted defendant had previous convictions actually increases the probability that the verdict of innocence is correct. Now, this might seem surprising, but it's not hard to see why it might be true. In the case of someone with previous convictions being in the dock, it may be that they're there largely because of those previous convictions. Perhaps the police checked out the usual suspects with a history of similar crimes, found one with no alibi, found some rather tenuous evidence possibly linking this person to the crime. And in such circumstances, the jury are probably absolutely correct in finding that person not guilty. Well, let's return to DNA evidence and look at some actual cases. First, a case of strong DNA evidence. James Hanratty was convicted of the so-called A6 murders and hanged in 1962. Doubts about the safety of his conviction played a large part in the abolition of the death penalty in 1969. The campaigning journalist Paul Foote was convinced of his innocence and wrote a whole book about the case. And after a vigorous campaign by Hanratty's family and others, an appeal was finally granted in 2002. There was DNA evidence from the crime scene in the form of a handkerchief which contained the murder weapon and also the underwear of one of the rape victim. Well, Hanratty's body was exhumed, and lo and behold, his DNA matched the crime sample. So this confirms that Hanratty is almost certainly the killer. It's remarkable how often this sort of evidence is retained after a crime. No one could have had any inkling in 1962 that this stored material, 40 years later, would provide vital DNA evidence. After all, DNA profiling wasn't even invented by Alex Jeffreys in 1984 until over 20 years after that crime. Now, a second case of strong DNA evidence. O.J. Simpson was acquitted of murdering his ex-wife Nicole in 1995, despite there being a DNA match. Anyone who saw the car chase live on television which led to his arrest will know that he was an obvious suspect, and so this DNA evidence certainly falls into the strong category, in that the evidence was there before the match was found. So how did O.J. get off? Well, possibly in relation to his admitted wife beating, the jury fell victim to the defendant's fallacy. The defence repeatedly argued that fewer than 1 in 1,000 wife beaters go on to kill their wives, and so argued that Simpson's abuse of his wife was irrelevant to the case. The problem with that, what might have happened there is that the jury interpreted that 1 in 1,000 probability as being the probability that he was guilty. But the 1 in 1,000 figure is actually the prior probability that someone who beats their wife will go on to kill the wife. Once the wife has been killed, that figure is no longer relevant. And the American mathematician John Allen Paulos showed that if a man abuses his wife and she's later murdered, the abuser is the murderer over 80% of the time. Now, of course, 80% in itself is not a conclusive figure, but when that's combined with the other evidence, including the strong DNA match, there is a mathematically overwhelming case that Simpson was guilty. However, he was found not guilty, and I'll leave you to make your own minds up as to whether that was the correct verdict. Now for a case of weak DNA evidence. Dennis Adams is probably a name that's not as well known to you as some of the other names we'll be discussing. But he is well known in statistical circles because of the role that Bayes' formula played in his trial. In 1991, Miss M was raped, and 4 years later, Adams was convicted on the basis of a DNA match. The match probability was claimed by the prosecution to be 1 in 200 million, but this was disputed by the defence, who claimed it should only be 1 in 2 million. The extraordinary thing about this case is that the DNA evidence was the only evidence offered by the prosecution. On the other hand, Adams had an alibi. His girlfriend said that he spent the whole of that night with her. And the victim herself said that Adams looked nothing like her attacker. She thought her attacker was in his early 20s, and she said she thought Adams looked about 40. He was actually 37 at the time. Well, Adams was convicted. There was an appeal, a retrial, a further appeal, throughout which the conviction was upheld. A defence witness at the trial and at the retrial was Peter Donnelly, a professor of statistics at Oxford University. And I can recommend an article in which he showed how the jury were instructed in the retrial how to use Bayes' formula. What this meant from the jurors' point of view was that they were given a questionnaire in which they could assign numerical estimates for various relevant probabilities. Then they were shown how to combine these with the aid of a pocket calculator and arrive at an overall probability of innocence or guilt. Now, I should say that it wasn't Peter Donnelly's idea to use Bayes' formula in this way. It was the defence barrister's choice. Also, we've no way of knowing whether the jury did actually make any calculations. They were only given this possibility as an option, and because what happens in the jury room has to remain private, we don't know whether they actually took up that option. What we do know is that they returned a guilty verdict. I must say, if I'd been on the jury, there's one particular probability I would have had difficulty with. I mean, the alibi wouldn't be too much of a problem. The girlfriend could have been covering up for her boyfriend or just misremembering 4 years after the event. But what about the evidence that the victim said that the accused looked nothing like her attacker? I mean, what sort of probability would you give to her being mistaken? You know, could it be 1 in 10, 1 in 100, 1 in a million? I've really no feel at all for what would be a sensible probability to assign there. In a later article, David and Thomas just assume for argument's sake that probability is 1 in 10 and reach the conclusion that if the match DNA probability were 1 in 2 million, that would lean then the overall probability would lead towards innocence. But if it were 1 in the 200 million claimed by the prosecution, it then tilts towards guilt. Though whether beyond reasonable doubt is another question. There was a further appeal, which was where the appeal court again upheld the conviction, and were also very scathing of the use of Bayes' formula in the way it had been used. The appeal court said that the jury should evaluate evidence and reach a conclusion, not by means of a formula, but by the joint application of their individual common sense. And Peter Donnelly, in his article, was quite critical of this statement. The problem is that where probabilities are concerned, common sense has a way of leading you into serious error. There are many correct results about probabilities that are counterintuitive and defy common sense. The appeal court subsequently provided guidelines for similar situations where DNA evidence is involved. And they said that judges should summarise such cases as follows. Suppose the match probability is 1 in 20 million. If you believe that number, then on average there will be 2 or 3 people in Britain whose DNA it could be, and probably no more than 6 or 7. And Peter Donnelly thought that this was very good advice. It immediately steered people away, or jurors away, from the prosecutor's fallacy, but it was logically correct. It followed the spirit of Bayes' theorem, but without needing the theorem itself to be explained. Well, I've mentioned Bayes' formula a couple of times, and perhaps we should see just what it is. It says that the probability of innocence given the evidence is equal to the probability of the evidence given innocence times the probability of innocence divided by the probability of evidence. And then there's a further way of expressing it which can be helpful in calculating the bottom term. In the various articles and expert reports that I've written, I've never actually used Bayes' formula because I prefer to calculate probabilities from first principles in a way in which the layperson can understand. But I've sometimes been asked by journalists or lawyers to explain Bayes' formula to them when it's appeared in papers written by someone else. And I've seen their eyes glaze over as I try to do so. It's very easy for numerate people, such as I expect most of us are, not to appreciate how difficult some of the notation we use can be for non-mathematicians. So here, for example, we've got some brackets which are used in a way they may not have seen before. To many people, brackets are just something that you multiply out when you take the product of A plus B with C plus D. So we've got not only brackets used in a way they haven't seen before here, we've got vertical lines, we've got some squiggles which stand for not, as it happens. We've also got, for example, we've got some products. We've got a product there, but with no multiplication sign between the two terms to say that it is a product. So simple things like that we take for granted can be difficult for the general public. So should Bayes' formula be used in court? My answer would be, in my view, no. But of course, Bayesian reasoning is essential, making sure one gets the various conditional probabilities the right way round. Well, let's now go on to profile evidence. Just as a DNA profile can be viewed as strong or weak, so also can a psychological profile. So again, a profile will be regarded as strong if someone's arrested on the basis of other evidence and then is found to have an appropriate profile, whereas it would be regarded as weak if there's been a trawl of the local community for someone with a certain profile and someone has been found in that way. And I'm going to discuss 3 cases of weak profile evidence which have led to serious miscarriages of justice. First of all, Stefan Kiszco. In 1975, a young girl was sexually assaulted and murdered in Rochdale. And after some time without any suspects, the police made a trawl of the local area, and for people with an appropriate profile, and as a result, Stefan Kiszco, a local oddball and loner, was interviewed. This was in the days before solicitors had to be present at police interviews, and after intensive interrogation, he eventually confessed on the grounds that he'd then be allowed home to his mum, and he hoped to sort things out the following day. Well, he did retract his confession the following day, but in one of the most shameful incidents in policing history, 2 policemen and a forensic scientist suppressed evidence that a sample provided by Kiszco at the police station showed that he was infertile and couldn't possibly have produced the sperm heads found on the victim's clothing. So in 1976, Kiszco was convicted, and it wasn't until 16 years later, after tireless campaigning by his mother and by a Manchester Evening News journalist, that the truth emerged and Kiszco was cleared, sadly dying of a heart attack just a year later. Then, in 2005, advances in DNA technology allowed a profile to be taken from the crime scene, and this was added to the national database. And then, by a remarkable coincidence, just a year later, Ronald Castry, on being arrested for a crime of which he turned out to be innocent, was found to be a match. Note that the DNA evidence in this case is weak DNA evidence, because at the time of the match there was nothing else to link Castry to that earlier crime. But very soon there was a whole lot of strong profile evidence emerged, including a history of paedophile activity. So he was arrested on the basis of weak DNA evidence, but that combined with the strong profile evidence made a very strong case against him. So he was convicted in 2007. But just to go back to Kiszco, I mean, why was it that this evidence, which would have meant he should never even gone to court, why was that suppressed? One possibility is that the police concerned took the view that confessional evidence was somehow the ultimate evidence of guilt, and that it should trump all other possible evidence which appeared to go against it. Well, if they did think that, then they would be falling to another fallacy, the interrogator's fallacy, described by Robert Matthews in 1995. This is the error of assuming that confessional evidence can never reduce the probability of guilt. It may seem self-evident that the probability of confessing if innocent must surely be less than the probability of confessing if guilty. But Matthews argues that for certain types of crime, this inequality may be reversed. In the case of terrorism, for example, an actual terrorist may be trained to resist interrogation and torture, and so may be less likely to confess than an innocent person subjected to the same intense interrogation. And it's worth noting that in the case of Leslie Mulsey's murder, the innocent Stefan Kiszco confessed, whereas the guilty Ronald Castry never did. The second case of weak profile evidence is that of Barry George. In 1999, TV celebrity Jill Dando was shot dead. And after a year with no suspects, a clinical psychologist was called in who suggested that police should look for someone with the profile of being a loner, record of stalking women, obsession with celebrities, interest in guns. Barry George fitted the bill. People with those particular profile aspects are probably quite rare, but in a heavily populated part of London where Jill Dando lived, there might be dozens of people with similar profiles. So again, this is weak profile evidence. Nevertheless, Barry George was found guilty. He failed the first appeal in 2002, but in 2007, a second appeal succeeded, a retrial was ordered, and he was found not guilty by unanimous verdict. The only hard evidence at the original trial linking George to the crime was a tiny particle of firearm discharge residue. This was considered to be so weak at the retrial that the judge deemed it inadmissible. So there's really very little to link George to the crime at all. George has again been in the news this year in that his quest for compensation for 7 years wrongful imprisonment failed. He was deemed not to be innocent enough. The adjudicators decided that there was indeed a case upon which a reasonable jury, properly directed, could have convicted the claimant of murder. I found that wording rather bewildering, really, and an insult not only to Barry George, but also to the judge and jury involved in the retrial. A third case of weak profile evidence is that of Colin Stagg. In 1992, Rachel Nickel was murdered on Wimbledon Common. A clinical psychiatrist named Paul Britton was called in, and he came up with an appropriate profile, and Colin Stagg was found to have exactly that profile and to have been on Wimbledon Common that day. The police seemed convinced that it must be him, and on the basis of that profile evidence, they set a honey trap for him, which didn't work. It was intended to get him to confess, but he didn't. He then spent 13 months in jail awaiting trial. The police were convinced his visit guilt, I think largely on the statement of the psychologist that the chances of two people with that particular profile being on the common that day were vanishingly small. Well, on the first day of the trial, the judge excluded the entrapment evidence. The prosecution, not having any hard evidence at all, withdrew its case, and Stagg was released. But the police and many journalists remained convinced that Stagg had done it. The judge was also castigated because they thought that Stagg had been released on just a technicality. And Stagg himself was hounded by journalists and the police for years afterwards. But both the judge and Stagg were vindicated many years later in 2008 when a tiny particle of DNA evidence on Rachel's body yielded a DNA profile which was found to match that of Robert Napper, who subsequently confessed. Napper was at that time serving a life sentence in Broadmoor for the horrific murder of a mother and daughter just a short time after he killed Rachel. I'll just conclude the section on profiling with a quote made here in Birmingham at the British Science Festival in 2010. And this was by Professor Craig Jackson, who said that behavioural profiling has never led to the direct apprehension of a serial killer or murderer. If the account of the role of the psychologist in the previous case sounds a bit like an episode of Cracker, well, it's perhaps no coincidence that the TV series Cracker was the first series was being shown just at the time of that case. So it might make a good film and television, but in real life, behavioural profiling's not got a very good record. And why has it led to so many miscarriages of justice? Well, it's again, I think, getting conditional probabilities the wrong way round. If a certain type of crime is committed, there's a good chance that the criminal has a certain profile. But just because someone has a certain profile doesn't mean that there's a good chance that they were the criminal in that case. Well, let's move on to probabilities of coincidence. So let's ask, can lightning strike twice? I'm going to carry out a little experiment. I'm going to ask 20 people, each to choose a number between 1 and 100. And then what I want you all to do is try and estimate what is the probability that some two of those 20 people have chosen the same number. So let me choose 10 people on the front row, starting here. So 3, 4, 6. Up to you. Could you each choose a number and write it down if you've got a piece of paper, or just remember it if you haven't. And then also the first 10 on the second row. That's up to you. No, it's up to you. So each of you do the same. And in case we don't have a swap there, could I just ask the first 10 people on the third row as well, just to choose a number, in case we have to go further back. So, I now want every one of you to decide what this probability is. What is the probability that two persons have chosen the same number? Give your answer as a percentage and choose one of these percentage ranges. Okay, has everyone now got an answer? So I'm just not going to count all the hands, but I'm just going to give a rough estimate and form a bar chart to find out what your answers are. So hands up if you think the chances of a swap are between 0 and 10%. 1, 2, there's a few, but we're quite low down there. Who thinks between 10 and 20%? Quite a few more. Who thinks between 20 and 30%? That's probably around about there. Who thinks between 30 and 40%? Sort of flattening out. Who thinks between 40 and 50%? A few more. Between 50 and 60%? Between 60 and 70%? Going down. Between 70 and 80%? This is all over the place, isn't it? Between 80 and 90%? Between 90 and 100%? Well, I can tell you first of all that you've done a lot better than the London audience did. And you've certainly done a lot better than when I asked the question to groups of medics or lawyers. But before we see what the actual answer is, well, let's work it out. Now, the probability, we want the probability that some two numbers are the same. Well, it's actually simpler to calculate the probability that all 20 chosen numbers are different and then subtract that number from 1 to get the answer we want. So what's the probability that all 20 chosen numbers are different? Well, whatever first number's been chosen, the chances of the second person choosing the same number are just 1 in 100. It's 99 in 100 that it's different, so that's 0.99. And then the chances that the third person has chosen a different number from the first two, well, there are 98 out of 100 numbers available, so that's 0.98, and so on, until we get to the 20th person, and the chances of the 20th person choosing a number different from the 19 already chosen is 0.81. So we've got the products of these numbers, all of which are quite close to 1, but by the time we multiply them together, we get quite a small number. 0.1304. So if we subtract that from 1, the probability of a matching pair is round about 87%. So I think anyone who chose this interval should give themselves a round of applause. And this is an example of the birthdays paradox, which says that you need only 23 persons in a room to have a better than evens chance of some pair having the same birthday. But we should perhaps go back to our 13% probability and see what's happened here. So can you each go through your numbers? What was your number?
42.
42. 64.
47.
47.
31. 37. 21. 16. 10.
23.
42.
Oh, we've already had a 42. I suppose it is the secrets of the universe and everything. Right. Well, let's go on to the multiple cot death cases. These were cases where two or more sudden unexplained deaths of babies occurred in the same family, and the mothers were then charged with their murder. As I've already said, I'm only going to give a brief summary here, but for more details you can read either of my two papers there. And I also mention a splendid new book called Math on Trial, published just this year, which looks at 12 court cases where maths has played a role in one way or another. And the first case considered is that of Sally Clark, the most well-known of the various cot death cases. Just by coincidence, I reviewed that particular book in this month's issue of the LMS newsletter. Well, before we come on to Meadows' law, when two or more sudden infant deaths have occurred in the same family, how suspicious should we be? We've just seen how coincidences occur more often than we might think. But back in the 1990s, there were some professionals working in child abuse who took the view that 2 or more cot deaths occurring naturally in the same family was somehow beyond coincidence. And this thinking was fueled by the dictum now commonly known as Meadows' law, that 1 sudden infant death is a tragedy, 2 is suspicious, and 3 is murder until proved otherwise. He said that that's a crude aphorism, but a sensible working rule for anyone encountering these tragedies. Well, the first objection to Meadows' law is that it turns traditional British justice on its head. We're supposed to presume innocence until proven guilty, and not the other way around, as is said there. But is there any scientific basis to Meadows' law? Certainly 2 or more cot deaths will be a rare event, but then so also will be 2 or more murders. And estimates I made based on the available statistics suggest that single cot deaths outweigh single infant murders by about 17 to 1. Double cot deaths outweigh double infant murders by about 9 to 1. And triple cot deaths outweigh triple murders by about 2 to 1. So with each successive death, there are grounds for some slight increase in suspicion, but to nothing like the extent that Meadows' law would suggest. And even in the case where you have 3 cot deaths or 3 sudden infant deaths, there is still no initial reason to presume that they are more likely to be murder than natural. So if we go on to the Sally Clark case, in 1996, baby Christopher died. There was evidence of a respiratory infection, and the death was recorded as natural. But when 2 years later, 8-week-old Harry died unexpectedly, Sally Clark was accused and convicted of the murders of both Christopher and Harry, with the prosecution claiming, in the form of Sir Roy Meadow, that the chances of 2 natural cot deaths in a family like Clark's were 1 in 73 million. In 2000, there was an appeal which was dismissed, and it was only when I read the judge's the judgment of that appeal that I was so horrified by what the judges had written and the way that they failed to appreciate the effect that figure of 1 in 73 million, which they admitted was wrong, but they totally failed to appreciate the significance that figure must have had on the jury. Well, the second appeal succeeded in 2003, but let's have a look at this flawed calculation that led to the 1 in 73 million. From a reputable source, they used the figure of the chance of a single cot death for a mother like Sally Clark, that is a non-smoking and affluent family. The chance of a single cot death is 1 in 8,543. So they said the chances of 2 cot deaths is 1 in the product of that number with itself, that is about 1 in 73 million. And there are 2 important issues here. First, is the squaring of that figure valid? But also, what does the figure mean anyway? And is it relevant to the innocence or guilt? So let's look at each of those issues in turn. First, the squaring would be valid only if the 2 events could be regarded as independent. But given that the genetic and environmental factors will be the same for both events, being the same family, it would be very surprising if they were independent. Indeed, figures in the same report from which those earlier figures were taken show, or certainly suggest, that in a family which has already suffered a cot death, the chance of a second is significantly increased. Because out of 323 cot deaths studied in that report, it was found that there were 5 previous cot deaths among siblings, but in the control group 4 times as large, there were only 2 previous cot deaths among siblings. If the events were truly independent, we would have expected 20. So already there's evidence that once you've already had a cot death in a family, the chances of a second are roughly 10 times what they would have been if there hadn't been one already. But perhaps the more important issue is, did the jury misunderstand what the 73 million figure meant anyway? That figure is a wrong, as it happens, estimate of the probability that 2 natural deaths will occur for a random pair of siblings. In other words, it's the probability of 2 deaths given innocence. But did the jury interpret that as the probability of innocence giving 2 deaths? Again, did they fall victim to the prosecutor's fallacy? Well, Sally Clark's second appeal succeeded. Later that year, Trupti Patel was tried for triple murder and acquitted. And Angela Cannings, later again that year, was freed on appeal from her conviction for double murder in 2002. Shortly after the Cannings appeal, the government ordered reviews of all similar cases and also set up an expert commission under the chairmanship of Dame Helena Kennedy, the Labour peer. And in 2004, the Kennedy report was published, giving a new national protocol for investigating all sudden infant deaths, not just multiple deaths, but all deaths, in the hope of at least giving the mothers a chance of finding out what was the cause of those deaths. So, just to finish this section, I'll give what I think of as the antidote to Meadows' law. I call this Sweeney's law, after the quote by the investigative BBC journalist John Sweeney, whose BBC radio and TV documentaries did so much to help the cause of justice for the cot death mothers. So he said 1 cot death is a tragedy, 2 cot deaths is a tragedy, and 3 cot deaths is a tragedy until the contrary is proved. Well, I'm going to just cover this salt poisoning case quite quickly. Ian and Angela Gay were foster parents of a child called Christian, and he died with high concentration of sodium in the blood. The Gays were tried and convicted of manslaughter, each sentenced to 5 years. The conviction was quashed on appeal and a retrial ordered, and the Gays were cleared at retrial. So, what went wrong here? Well, the prosecution claimed that the Gays had force-fed salt to Christian as a punishment. And a key paper cited by the prosecution experts was non-accidental salt poisoning by the same Roy Meadow that we've already met. And this particular paper looked at 12 cases of known salt poisoning, and it showed that in every single one of those cases there was high sodium concentration in the blood. So imagine you're on the jury and you're told that in 100% of all known cases of salt poisoning there is high sodium concentration in the blood, and here we had this child who's died and has been found with high sodium concentration in the blood. That 100% figure might look quite convincing, but I hope you all appreciate by now that, again, we're looking at a conditional probability the wrong way around. What does this tell us about the likely guilt or innocence of the Gays? The answer is almost nothing. It might well be that whenever you have a case of salt poisoning, you get high sodium concentration in the blood, and it's hardly surprising that should be the case. But it doesn't necessarily mean that someone with high sodium concentration in the blood has been poisoned with salt. And there are other causes of high sodium concentration. Experts in the retrial argued that reset osmostat, which stopped the body from regulating its salt content, was the more likely cause in this case. Well, finally, let's have a look at the case of Harold Shipman. In January 2000, Shipman was convicted of murdering 15 patients and forging the will of one of them. A subsequent inquiry by Dame Janet Smith found that he'd almost certainly killed 215 patients and probably around 250 in total. If we look at this timeline here, we see that he killed over 200 people between 1975 and March 1998, at which point there was a first police investigation. But after that, he went on to kill 3 more of his patients, and it was only when he forged the will of the last of those that there was a second police investigation which led to his arrest and conviction. Now, if anyone's expecting me to show that Harold Shipman's conviction was a miscarriage of justice, I'll have to disappoint them. The miscarriage of justice in this case was really this first and botched police investigation, which allowed him to kill 3 more victims. So what went wrong with that? Well, it arose in March 1998 when Dr. Linda Reynolds of the Brook practice, which was opposite Shipman's surgery, noticed that the Brook practice had countersigned 16 cremation forms for Shipman in the previous 3 months. In the same period, the Brook practice had only 3 cremation forms, despite being nearly 3 times the size of Shipman's. So Shipman's patients appeared to be dying at around 15 times the rate of the Brook practices, and Dr. Reynolds reported her concerns to the police. So the first police investigation took place in March and April 1998, and Detective Inspector David Smith was assigned to the job. So he found that Shipman had certified 31 deaths in the previous 6 months and got medical records for 14 of these and started to look for common features. Well, first he found that none of the 31 deaths had been reported to the coroner, which was quite unusual because one expects about a quarter of all cases to get reported to the coroner. The chances of none out of 31, that has a probability of around 1 in 7,000. Not difficult calculations to make, just a question of calculating various binomial coefficients. Smith also found that 13 out of 14 were elderly female. Chances of that are around 1 in 200. So nothing conclusive as yet, but the really damning statistic was that 7 out of the 14 were either found by Shipman or seen by Shipman in the previous 24 hours, with Shipman's visits unannounced. They died alone, they died during the day, fully dressed, and they showed no previous signs of being ill. Now, any one case fitting all those 4 circumstances would be very unusual, but there to be 7 out of 14, I mean, you work out your own likely probability, you'll find it's 1 in many millions and almost certainly 1 in trillions. It's just, almost inconceivable that could happen. But what did D.I. Smith conclude? He concluded that there was no substance to Dr. Reynolds' concerns. And what he appeared to have done, he looked at the other 7 out of these 14, and he found that several of those couldn't possibly have had anything to do with Shipman. He seemed to be looking for links between all the murders, but not appreciating that there is bound to be some background noise of patients dying naturally amongst all the sort of mayhem of murdering that was going on. So I'm sure that if Smith had only taken his figures to a mathematician, he would have been told straight away that some further investigation should take place. Now, of course, we should beware of the prosecutor's fallacy at this point, and it could just be that Harold Shipman was the unluckiest doctor in the universe, and that he was just unlucky and these multi-million to 1 chance had happened to him. But the point is that there was no need to accuse Shipman on the basis of those statistics. All it needed was to perform an autopsy on one of his victims, and that would have revealed straight away that he'd given lethal overdoses of diamorphine, which killed them. And it so happened that at the time of this first police investigation, there were bodies of his latest 2 victims on the premises of funeral directors, and it would have been a very straightforward matter to have carried out such an autopsy. So, I hope I've given you some indication of the important role that mathematicians can play in the justice system, and I'll stop there. Thank you.
I was once told by an Australian that they'd had difficulty with DNA statistics because they found that the statistics for Aborigines weren't typical because of their sort of tribal living, and so they'd wrongly convicted a number of Aborigines. And I wondered how you ensure that when you're getting statistics, which are inevitably for a sort of general population, that they're applicable in particular cases.
Yeah, I'm certainly not an expert on DNA profiling, and I tend to take the statistics that the expert produce at face value without checking them. But I'm more concerned is whether the statistics are then interpreted in the right way rather than whether the figure given is accurate. So I'm afraid I can't really help you with that one.
I just wanted to perhaps help out with that first question that you had about statistics for DNA profiling and interrelatedness amongst populations. I'm a forensic scientist who uses the statistics. And when we do the calculation using Bayes' theorem, we have a factor that we include which takes into account how related people might be. So what we do is we actually get a group of people from say, an Afro-Caribbean population or a Maori population or something like that, and we look at how often you see the same genetic profile in those individuals. And you can actually then do some frequency analysis, which gives you a sort of a factor that you can include in your calculation that then takes into account how related people might be. Does that help?
Yeah, thank you. I should perhaps mention also that in the Adams case, which I mentioned earlier, that there was also a half-brother on the scene whose DNA was not known. So there again, once you've got family members who might be involved, then statistics can change a lot.
Do you think that mathematical evidence should be taken as actual evidence or simply a sort of indicator to the jury as to whether or not they should find the person guilty or innocent?
Yeah, I'm personally not keen on a formula being used to derive an overall probability of innocence or guilt. Partly because no one's really sure what constitutes reasonable doubt anyway. I think my main concern is that probabilities where they are used in the right way and that they're not used in misleading ways. But certainly, where valid mathematical formulae are used, then it's important that they should be used. And mathematicians, I don't think, are involved often enough in cases where they can play a role, largely because the people involved in the trial possibly aren't aware that fallacies are happening that they're totally unaware of.
We know that humans look for patterns and that they tend to see patterns where there are none and are consequently quite superstitious. And we also know that many humans don't expect coincidences or see things as coincidences which aren't like the two numbers that were chosen. And that certainly people outside of those who are quite well trained in maths are particularly susceptible in that sense. So is there a case for, almost rather than trying to explain statistics and probability to juries, more making the general public more aware of just how little they can trust their instincts and how useless statistics are to most of them unless they're trained to use them?
That's a very good point, and I think it is happening more and more. We get people like Marcus de Sortoy on television putting people right on such things, and you mentioned Marcus de Sortoy. Perhaps I should just mention his example of the birthdays problem when he quotes it is to say that on a football field where you have 11 players on each side plus the referee, that's 23 people, there will be more likely than not 2 of those 23 people who share a birthday, and it seems quite remarkable, but it is the case.
You mentioned the case of O.J. Simpson, and people might like to know that some years later he did actually admit his guilt in his autobiography, and he was then actually jailed for armed robbery. So the story sort of has a happy ending, that he did end up in jail.
I think his book said, "This is what I would have done had I."
He wrote an autobiography in which he said, hypothetically, had I wished to kill my wife, this is what I would have done.
Yeah.